Good evening, ladies and gentlemen, and I hope that every one of you are in good health conditions right now. And to continue with our subject on labor laws 1. Now, today is September 1, and this is the continuation of our discussion on the codal provisions of the labor code. Okay, so Article 13 is the contents of this article are the definitions that you must try to remember as we go along because you will have to be encountering these words and you must be alert on what it connotes and how would you define it in such a way that you will have a clear understanding of the area that is being covered by that particular word. Okay, so worker here simply means that under the provisions of the labor code and its implementing rules and regulations, as well as the provisions of subsequent amendments to the labor code, simply means that any member of the labor force, whether employed or unemployed. So here, even if you are considered as not yet employed, uh, there are those provisions that would in effect cover you, okay, because we said among others that the provisions of the labor code provides benefits from birth to death, so that from birth to death, in other words, before even you uh, come into being, okay, and be a part of the workforce, you are covered already by the provisions of the labor code. And even after you have already retired from the workforce, you are still entitled to benefits, and even at the time of death. So that is the way we have to understand unemployed here, because probably what you may think of is the fact that the provisions of the labor code provides only for those who are employed in the service of unemployment or an employee or management. So, okay, member of the labor force, whether employed or unemployed. Now, uh, recruitment and placement is something that you should also remember because these are two different words, but somehow would purport to uh, consider only an act uh, that would vary in certain stages by the way a person would commit the said placement and recruitment. So, recruitment and placement as provided for under the labor code refers to any act of canvassing, enlisting, contracting, transporting, utilizing, hiring or procuring workers, and includes referrals, contract services, promising or advertising for employment locally or abroad, and whether for profit or not. Remember that this definition is all encompassing, that you must have to remember that there are series of acts or individual and separate acts for that matter that would come into play upon which you will be considered as having committed recruitment and placement. Okay, so it says it refers to any act of canvassing. You know what is canvassing? Okay, um, you try to go to some places and tell them that there are offer for work, and you are there to canvas who are those willing to be employed pursuant to that offer of work. enlisting, you enlist. When you say enlisting, you try to list all those who are desirous of being hired to work in accordance with the offer. Okay, transporting. When you by the word transporting, you have to board them to a vehicle. Okay, whether it's sea, air, or in whatever means by way you will have to travel for purposes of letting those persons who are traveling, okay, by way of being transported, be able to secure a job. Utilizing, when you start to uh, hire them, in a sense that you really are trying to impress upon them that there is really work, hiring or procuring workers. Now, uh, recruitment and placement even includes referrals. When you refer someone to somebody for purposes of him being hired to work, that would also be considered as recruitment and placement. Okay. Now, uh, promising or advertising for employment. The moment you advertise that there is opening for work, there is job placement, then that is considered as recruitment and placement already. You go to the radio stations and pay a certain amount for purposes of announcing that there is job opening. That is advertising. Now, it also, recruitment and placement here would refer to jobs that are all being offered here and abroad, meaning locally and abroad, domestic or uh, abroad or overseas. Okay, and whether for profit or not. So understand these wordings of recruitment and placement, especially the act upon which it covers the definition of what recruitment and placement is all about. Now, there is a presumption in this particular provision of recruitment and placement that any person or entity, okay, so it can be one person, it can be a, 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 a group of persons, or it can be uh, a corporation or just a business establishment or entity for that matter, which in any manner offers or promises for a fee employment to two or more persons shall be deemed to have been engaged in recruitment and placement. There is this presumption of having committed the act of recruitment and placement if and when that person again promises or offers, underline the word offers or promises for a fee and employment to two or more persons, he is deemed to be engaged in recruitment and placement. So the bottom line here is the number of persons being recruited, two or more, for a fee, okay, and you promise him employment or uh, job to two or more persons, then you are deemed to be engaged in the act of recruitment and placement. So much on this recruitment and placement definition. But then again, try to remember the series of acts that would constitute recruitment and placement, or series or independent acts, okay, that would consider you as having committed already the act of placement, recruitment, and placement, and even to that extent that there is a presumption of a law that when you start hiring two or more, or promising to hire, or promising to engage, and then you what you call this, in return for that promise, or in return for that offer that he be able to work, and then you have to pay that person for a fee, and then he or she recruits two or more, then he is engaged in the act of recruitment and placement. Very clear on this, okay? Now, uh, in our jurisdiction in the Philippines, there are those so-called private fee charging employment agency. Okay, so here, these are the ones that would engage your services, but you have to pay uh, for the fact that they are the ones responsible for you being hired. That is why it's called private fee charging employment agency. Therefore, is a person or entity engaged in recruitment and placement of workers for a fee which is charged directly or indirectly from the workers or employers or both. Okay, are you familiar with? You are probably familiar with this that when there are workers demand to work in Metro Manila, you bring them there, and when you have brought them already and they be able to start with their work, they have to pay you for uh, the um, the services that you have rendered upon them, upon which they were able to land a job. Or it's the employer who will pay you as a recruiter, okay, as one who has recruited these workers for them to be able to work in that particular uh, company or for that particular project or in whatever way, as long as you hired, they are being hired by the services that you have rendered, and then you are considered as engaged in the so-called private fee charging employment agency. Now, here, ladies and gentlemen, in under this definition are two words that you will have to remember as always: license versus authority. Okay. Now, let us go to license. A lisensya, by the word license. So it is a document that is issued by the Department of Labor that authorizes a person or entity to operate a private employment agency. License means you are given that document to be able to establish a private employment agency. So here, ladies and gentlemen, um, a license, as you probably may have known also in some other business establishments, before they can start their business, is you have to procure or secure a license from where? A license from, for example, in the local government unit, from the local government uh, licensing unit before you can start your business. So it is the authority for you to establish uh, a an office or an edifice or in whatever way you can call it, that you are being seen as having started to a business of recruitment and placement of workers. So it is what? A document for purposes of operating a private employment agency. Who issues this license? It is the Department of Labor and Employment. Now, what about authority? Okay, it is the other document that is issued by the Department of Labor that authorizes a person or association to engage in recruitment and placement activities as a private recruitment entity. In other words, there are two documents that you must have to understand in this situation. One is the license to operate. What is the license there? To open a business, to open a building for that particular business of recruitment and placement. What about authority? It is now the other document that you have to secure for purposes that you are specifically authorized, okay? Authorized okay, to recruit, to engage in the recruitment and placement of workers as a private recruitment entity, a private recruitment entity. So, for example, you have the Parola, um, Manpower and Labor Services Incorporated or Inc. Okay. Now, before you can start your business as a recruitment and placement, uh, as a private recruitment entity, private recruitment entity, you must have to secure a license. But for you to further undertake recruitment and placement is the other document that you will have to secure, and that is already the authority that you can engage, okay, in the recruitment and the placement of workers as a private recruitment entity. So license is different from authority. License is for you to operate a business, but authority is the authority that will give you the power to recruit workers as a private recruitment entity. Now, what is a private recruitment entity then? It is again any person or association engaged in the recruitment and placement of workers locally or overseas without charging directly or indirectly any fee from the workers or employers. Okay, so here you establish a private recruitment entity, okay, for purposes of hiring and recruitment and placement of workers, whether to work here locally or abroad, without charging directly or indirectly any fee from the workers or employers. Okay, now seaman is now referring to persons employed in the vessel engaged in maritime navigation. Okay, so this is the one that are in demand right now. Okay, overseas employment means employment of workers outside the Philippines, while immigrant means any person, worker, or otherwise who immigrates to a foreign country by virtue of an immigrant visa or resident permit or its equivalent in the country of destination. So when you apply and to work abroad and you are to be given a permit, okay, or a visa for that matter, you are considered as an immigrant. Okay. Now, so very clear, huh? What is important is for you to remember what is recruitment and placement, what is a license, and what is authority. Okay. So I will now proceed. So going to Article 14. Now you just read this. It's just a matter of establishing uh, the setup of how employment promotion is being undertaken, that employment promotion is really lodged before the Department of Labor and Employment through the Secretary of Labor. Okay, let's go. Now, the Bureau of Employment Services is an office that is attached to the Department of Labor and Employment. Okay, okay. Now, this one is very important for us. This is the jurisdiction of the um, Department of Labor and Employment regional offices, and even the satellite offices. For example, in Caraga region, we have the Department of Labor regional office based in Butuan. What about in Surigao City? They have the so-called satellite office. In other words, it is just an office that is being established, but the processing of all claims will be there in the regional office because the provisions of the labor code clearly provides that the regional office of the Department of Labor shall have original and exclusive jurisdiction over all matters or cases involving employer-employee relationship, including money claims arising out or by virtue of any law or contracts involving Filipino workers for overseas employment, except seamen, provided, okay, that now we have to take note that here, um, later on we will be discussing jurisdiction, and by and large I am discussing this at this point in time because the Dole Regional Office has jurisdiction over money claims. Okay, but the one that has now jurisdiction over other cases, including termination of employment and even claims for overseas contract workers, okay, are now covered by the provisions of the National Labor Relations Law, upon which we will have the labor arbiters. Okay, so we will go to that later on. I don't want to what you call this make confusion at this point in time, except that this provision provides that there are instances where the claims of workers are to be handled by the Department of Labor regional offices, money claims. But more than the Department of Labor and Employment regional offices are those that are now covered by the provisions that all labor uh, disputes, especially with respect to termination of employment, okay, and even the claim for overseas workers, OFW, are now being handled by the National Labor Relations Commission, particularly the labor arbiters. Now, we will have a separate discussion on jurisdiction of the Department of Labor and Employment and the National Labor Relations Commission or the labor arbiter, and even to that extent, the jurisdiction of the so-called voluntary arbitrator. So at this point in time, just make that in your mind that in claims involving workers, the Department of Labor and Employment has jurisdiction over this particular item of uh, a claim, but more than this claim are also the claims that are being handled now by the National Labor Relations Commission through the so-called labor arbiter. Okay. Okay. Now, Article 16, it says that except as provided in Chapter 2, no person or entity other than the public employment offices shall engage in the recruitment and placement of workers. So this is a policy statement na sa hiring ng mga empleyado na gusto mo trabaho, whether abroad or locally, supposedly, and recruitment will be handled by public employment offices. We have the PESO. You probably may have known what this office is all about. This is the PESO that offices that are being established all over the country. Each local government unit has its own PESO office. Precisely, this is the one that is provided that supposedly, okay, for purposes of recruitment and placement, it has to be handled by public employment offices. But however, there are exceptions, okay, and the exceptions are those private recruitment and placement agency or entity. Now, Article 17 has already been amended. This is now covered under the OWA. Okay, so now Article 18. ban on direct hiring. Now, very important, you put 3 stars here, that this is a very important provision. It says that no employer may hire a Filipino worker for overseas employment except through the boards on entities authorized by the Secretary of Labor. Direct hiring by members of the diplomatic corps, international organization, and such other employees as may be allowed by the Secretary of Labor is exempted from this provision. Now, this is again a policy statement na ang tanan na motrabaho abroad or overseas, kinahanglan mo agi gadud na mga entity that has been authorized by law. So for example, in Saudi Arabia, a company there is engaged in construction and they wanted to hire Filipino overseas workers. They cannot just hire you directly, but you have to pass an agency or you have to pass an office that is established by law. There are three, this is a tripartite agreement. One, you, the agent, and the principal. Where is the principal? In Saudi Arabia. Who is the agent? The one authorized to hire you and you as the worker. It can never be that that worker can go straight to the principal. No. There is, why is it so? Mungutana ka mo, dili man pwede na maka-hire directly ang mga foreign employers or the principal. The answer is jurisdictional issue, that in the event, okay, that there are violations of the contract, dili man nato sila pailan ng kaso kay they are outside of the jurisdiction of our country. Therefore, haman nimo i-file ang kaso sa ahente niya dinhi sa Pilipinas. Precisely, that is the rationale why there is ban on direct hiring, because in the event of any violation or in the event of abuses of these employers, ang ato gobyerno or ikaw mismo jaoy recourse to go against the agent here in the Philippines, because the agent here in the Philippines stands for and represents the employer abroad, the one who is the so-called principal. So kung dili daw nato himuon na mag-direct hiring, chances are kaluluoy ang mga empleyado, because the moment there are certain violation of the contract itself, dili man nato sila malagas dito sa ila lugar kay waya may ato jurisdiction over the person of the employer, diba? So here, but this is not an absolute rule, because direct hiring can be done by what? The members of the diplomatic corps, international organizations, and such other employers as may be allowed by the Secretary of Law. So, doon mga members of the diplomatic corps, diba? Direct hiring sila, pwede. International organizations, they can also be considered as exempted from the ban on direct hiring. Okay, very clear. Okay. So entities authorized to engage in recruitment and placement of workers may include public employment offices, the Philippine Overseas Employment Agency or Authority, private recruitment entities, private employment agencies, shipping or manning agents, construction contractors, and such other persons or entities as may be allowed or authorized by the Secretary of Labor and Employment. So, this one are the only ones being authorized to hire workers who work abroad. It can be a private recruitment entity, it can be a private employment agency, Okay, it can be a shipping or money agent, but by and large, the Article 18 already gives you some of the exceptions. Sima na nga yan. Maghanap. Direct hiring by members of the diplomatic corps, international organizations. Okay? So, claro, there is a ban on direct hiring. Who are authorized to hire for workers to work abroad? These are the ones: public employment offices, POAA, the private recruitment entities, the private employment agencies, the shipping or manning agents or representatives, construction contractors, and such other persons or entities as may be authorized by the Secretary of Labor. Now, uh, class, it has always to be that this is a tripartite contract. Okay? There has to be always an agent here in the Philippines. Again, what is the purpose of that agent? It is for that agent to represent the principal abroad. The moment there are a violation or violations of the contract, the employer can go against the agent here in the Philippines. Okay? Very clear. Okay. So you just read this. Okay. This has already been assumed by the Article 20 has already been assumed by the Philippine Overseas Employment Agency, the POAA. So let us okay. Now, Article 22 again is very important. Okay, you put 3 stars here. So how many na? Itong ban on direct hiring and even before, you put here 3 stars. The mandatory remittance of foreign exchange earnings. Okay? Kung magtrabaho ka abroad, and some of you probably may have already had that experience to work abroad, or your earnings will not go to you entirely. Because there is these provisions that it shall be mandatory. The word is shall. In other words, it is obligatory. Okay? And in fact, this wordings is clear and explicit. Shall pagani, mandatory pagadun. Okay? It shall be mandatory for all Filipino workers abroad to remit a portion of their foreign exchange earnings to their families, okay, dependents, and or beneficiaries in the accordance in the country in accordance with the rules and regulations prescribed by the Secretary of Labor. Foreign earnings, foreign exchange earning. So you will have to remit a portion, not all, but a portion of your earnings to your family or families here in the Philippines. It is considered as what? Mandatory. Okay. Now, what are pilaman and remittance? Okay. It states here. It shall be mandatory for all Filipino workers abroad to remit a portion of their foreign exchange earnings to their families. Okay. And the following are okay. Now, for seamen or mariners, 80%, okay, of their basic salary. Okay, so take note that when you talk about foreign exchange remittances, it refers only to a portion of your basic salary. Well, you are some of you or most of you are working already. You know what is a basic salary and what are those outside of basic salary. Okay, overtime pay is not part of basic salary. Basic salary is the one, for example, in this case, where you are supposed to engage in the minimum wage, for example, you know that the basic pay is 305 in uh, in Caraga, and 15 is the cost of living allowance. So what is the basic pay? It is 305. What about the 15? It is the cost of living allowance, making that the prescribed minimum wage in Caraga region is 320. Okay? The same is true with you having to work abroad, that you have your own basic salary, but you also have other earnings other than the basic salary. So what is mandated by law is for you to remit a portion of your basic salary to your family or families here, dependents, or whatever, as long as there is a contract, or rather that trace that you are remitting a portion of your earnings. So for seamen and mariners, 80% of their basic salary must have to be remitted here in the Philippines. So for example, if the basic salary is 100, then 80 pesos will have to be remitted, or $80 or what foreign earnings man, $80, $100 for example, $80 will be remitted to the Philippines, and to your beneficiaries here in the Philippines. Workers for Filipino contractors, it is 70% of their basic salary. Now, professionals whose employment contract provide for lodging facilities, you have 70%. Professionals without board and lodging is 50%. And domestic and other service workers, you remit 50% of your basic salary. That is the foreign exchange earnings. Okay? So take note of this. Ang pinakataas ang mga marinero nato, mga seamen. Okay? Because 80%. Why is this so? Well, 80% because of the basic, ha? Kay dako mangudonan ila income while on board a vessel, because aside from having a basic salary, they are also entitled for some other French benefits. Mas dako pagani ang ila French benefits i-compare din mo sa basic salary. What is um, mandated by our law is for one to what? Remit foreign exchange earnings, and foreign exchange earnings here refer to what? The basic salary of that particular worker. Okay, so you take note of this. Okay, uh, the this one, this has already been amended, and we will go to this later on. Okay, now Article 26 is again a very important provision. You underline and put 3 stars here. Now, travel agencies are prohibited to recruit. Travel agencies and sales agencies of airline companies are prohibited, underline the word prohibited, from engaging in the business of recruitment and placement of workers for overseas employment, whether for profit or not. Claro, ha? Travel agencies are prohibited to recruit. Travel agencies and even sales agents of airline companies are prohibited from engaging in the business of recruitment and placement of workers for overseas employment, whether profit or not. So, yung mga travel agents, they are only exclusively for one to be issued, for them to conduct business for purposes of leisure or travel, but not for them to engage in the recruitment and placement of workers. That is, in fact, prohibited. In fact, even sales agents of airline companies. So there are two um, entities here that are prohibited from engaging in the placement and recruitment of workers. One is the travel agency, and sales agents of airline companies are prohibited from engaging in the business of recruitment and placement of workers for overseas employment, whether for profit or not. Okay? Again, Article 27, you put three stars here. Now, is there a citizenship requirement for persons, corporations, partnerships, or entities for purposes of engaging in the recruitment or placement of workers locally or overseas? The answer is yes. It says that 75% of the authorized and voting capital of stock of that corporation must be owned wholly by Filipino citizens. Okay? 75%. A corporation that is desiring to engage in the placement, recruitment, and placement of workers must comply with the citizenship requirement. What is the citizenship requirement? It is 75% of the authorized and voting. Take note that it speaks of authorized and voting capital stock. It is not only authorized stock, but it is authorized and voting capital stock shall be owned by and controlled by Filipino citizens. So there is that cap. So an alien cannot engage in the recruitment and placement of workers. He has to divest only, or rather to invest only 25%, but not the whole capital and voting stock, because it is limited only the 75% capital and voting authorized and voting capital stock shall be owned by the Filipino citizens. Okay. Now, so if you want to engage in the business, having partners with the aliens, it has to be that it is 75, 25. 25 will be for those aliens, while 75 will be for the Philippines. It is what authorized and voting capital stock of that corporation. It has to be established that 75% is owned and controlled by Filipino citizens for purposes of engaging that corporation in recruitment and placement of workers to work locally or overseas. Okay. Uh, now, okay. So, well, license or authority can be suspended or cancelled by the Department of Labor for violation. Okay. Now, the Article 36 is again, you put three stars here because this is the power of the Department of Labor and Employment, okay, to restrict and regulate the recruitment and placement activities of all agencies within the coverage of this book. So the Department of Labor and Employment has regulatory powers. It has also visitorial powers. So Article 36 and 37 are inherent in the Department of Labor and Employment to undertake regulatory powers and visitorial powers. Okay. Now, let's go now to Article 38. This is more something that you will have to understand because this is the heart and soul already of recruitment and placement of workers, illegal recruitment. Now, um, the law of the Republic of the Philippines gives so much emphasis on hiring. Who are those authorized to hire? But also, uh, our framers of the labor code has this foresight that eventually, because of the influx of uh, the hiring of workers to work abroad, there may be some who will manipulate, or if not manipulate, take advantage of the situation by engaging in the so-called illegal recruitment activities. Okay? So, Article 38 speaks of how would one commit illegal recruitment. Okay? So, simply stated, illegal recruitment, once you recruit without any license or without any authority, therefore you are deemed to have committed illegal recruitment. So, but now, this is the general statement that supposedly for one to commit illegal recruitment, he or she must not be in a possession of that document. What is that document? License and authority. License is to establish, authority is the power to recruit. License is to operate business. If you have, if you do not have these two documents with you, then you are committing illegal. But however, as as we progress, there are instances that even if you are a holder, okay, of a license, or even if you have a holder of an authority, you can still commit illegal recruitment, and we will go to that later on. Okay. Um, so illegal recruitment can be committed by a syndicate or in a large scale. Okay. And when you this illegal recruitment is committed by a syndicate or large scale, it shall be considered as an offense involving economic sabotage and shall be penalized heavily. Okay. So, illegal recruitment again can be committed by a syndicate. Illegal recruitment can be committed in a large scale. Duha, um, committed by a syndicate or committed uh, in a large scale. Okay? Now, when is, para madali ra nimo pagsabtan, an point of reference here as to the difference between illegal recruitment by a syndicate and illegal recruitment in a large scale, ang mga tag-recruit. So, illegal recruitment is deemed committed by a syndicate, sindikato, if carried out by a group of 3 or more persons. Tuyo, at least tuyo. So, an syndicate, for one to be considered as illegal recruitment committed by a syndicate, there are three there are three who are conspiring and confederating with one another in carrying out an unlawful or illegal transaction. Now, on the other hand, illegal recruitment is deemed committed in a large scale if committed against 3 or more persons individually or as a group. Are you following me? What is the difference between illegal recruitment by a syndicate? Ang mga sindikato, kinahanglan ang ilang numero na nagkumbuya sila, conspiring and confederating with each other, tuyo ka tao na nag-engage in illegal recruitment. Now, will it matter kung pila ang ila na recruit? Even if there is only one who is recruited, as long as there are 3 persons or more who had conspired or confederated to hire that one person illegally, then he is committing uh, a um, a crime known as illegal recruitment by a syndicate. On the other hand, if there are victims, bisan kung ikaw ra isa ang nag-hire, but there are three or more persons who have been victimized already because the hiring is considered illegal, then you can commit already illegal recruitment in a large scale. So, bawaan ninyo sa sindikato, kinahanglan tuyo gadud ang mag-recruit. So, bisan kung isa ra ka buok ani dyan na recruit, kay tuyo man ka buok ang nag-hire and they are conspiring and confederating each other, it is committed by a syndicate. On the other hand, if there are three or more persons individually or a group ang na biktima to you or more na biktima ng illegal recruitment, even if it is committed by only one recruiter, it can be considered as illegal recruitment in a large scale. So, take note of the difference. Syndicate, kinahanglan tuyo ka buok ang nagkumbuya para mag-recruit. Pero even if there is only one who is recruited, or what is important is that there are three or more, then they can be considered as what? Illegal recruitment done by a syndicate. On the other hand, illegal recruitment in a large scale is committed against, meaning the victims are three or more, even if the recruiter is only one, but he has recruited illegally three or more victims, three or more workers, he can commit illegal recruitment in a large scale. So large scale, therefore, clearly provides victims. Syndicate clearly indicates ang mga recruiter. A large scale is victims. Syndicate are the recruiters. Three or more recruiters, even if there is only one, but the hiring is illegal, that can be committed, and that crime committed is illegal recruitment by a syndicate. Kung tuyo ka buok ang biktima, even if there is only one recruiter, but he has victimized already three or more, okay? Three or more persons individually or as a group, three or more, then he can commit already the crime of illegal recruitment in a large scale. Okay? So we will go to this later on, and we will continue. We will have the provisions on illegal recruitment, okay, and then try to finish this off in our next meeting. I will be giving you more on this siguro tomorrow. We will continue tomorrow, even if our time is only for tonight. But considering that I am at liberty to record my lecture, you just follow this up. Okay, so this will be all for the moment, and try to follow up the next segment, the follow-up of this lecture on illegal recruitment. Thank you very much for following me, and I'm looking forward for, as always, for your understanding in the way we're handling this class or through online. Thank you. God bless. To God always be the glory.